The next case I want to review is the Trosiak case, Trosiak versus BC, British Columbia, the Attorney General of British Columbia. That was heard in 2003 at the Supreme Court. This case involved the right of a father to be named on his child's birth certificate and to have his surname involved in the naming of the surname of the child. So the case involved Daryl Wayne Trosiak, who was the father, and Rennie Ernst, who was the mother. The two had triplets in January 1996. Ms. Ernst marked the father as unacknowledged on the birth certificate, which, under the BC Vital Statistics Act, allowed her alone to choose the child's surname. So this was completely at the mother's discretion to say that the father was unacknowledged. And then once that category was established, the father had no involvement under the law to be named as the father, nor to be named that the children might be named with his surname. So the couple became estranged after the birth of the triplets, and in April 1997, the father applied for and was granted access to the children. A month later, the mother was granted interim custody and child support, and paternity tests were also ordered. A couple months later, in September, the court recognized Trosiak as the father, but declined to amend the birth certificate. The father applied for an order compelling the Director of Vital Statistics to amend the birth registration forms to name him as the father and to change the surnames of the triplets to Ernst Trosiak from Ernst. He also asked the court to strike down the section of the law, in particular the Vital Statistics Act, because it discriminates on the basis of sex. The application was dismissed at trial and upheld on appeal, but with a dissenting opinion. A couple of years later, when it got to the Supreme Court, first of all, the Supreme Court granted leave to appeal on this case, and then it allowed his appeal. So it basically overturned the two lower courts' decisions and ruled in Trosiak's favor. The relevant sections of the Vital Statistics Act of BC were struck down as being unconstitutional and discriminating on the basis of sex. Now, what were the reasons for this decision? Well, the court argued that there are significant interests at stake. They argue that there is harm to the father's dignity. There's no record of the biological children's ties, and not only that, he was not allowed to participate in choosing the surname of the child. The court argued that this is a way of participating in the life of the child, and it symbolizes familial bonds. So, unacknowledging a father can have a valid basis, the court acknowledged. So, in cases of rape or incest, these are valid reasons to not acknowledge a father, but it does not justify arbitrary unacknowledgement. So there needs to be a reason for not acknowledging the father. It can't just be at the whim of the mother.